You slipped and fell at a grocery store. Aren't they automatically responsible for your injuries? Hi, this is Paul Hernandez, attorney at Kalfus Nachman, litigating cases across Virginia and North Carolina. Slip and fall cases are very difficult to handle for most people. The insurance companies that commercial businesses and grocery stores hire are very aggressive and try to find any way to deny your claim. Most people think if you fall at a commercial business or at a grocery store, the business or store is automatically responsible to pay that injured person. That is so far from the truth. In a slip and fall case, the injured person is required to prove that there was a defect or a foreign substance that caused the individual to fall. That injured person next needs to prove that the business or store was aware or should have been aware of the defect or foreign substance on the floor. Then the injured person must prove that the defect or foreign substance was not open and obvious and observable by the injured party. Lastly, the injured party must prove that the defect and fall was the cause of their injuries. That last element is usually the easiest to prove. The other three can be problematic. Let me share with you a case that we handled that almost was lost until we found the smoking gun. A young lady was shopping at a grocery store with her mother and her daughter, buying groceries for a Memorial Day weekend extravaganza. Our client had the shopping cart list and was pushing the grocery cart while her mother and her daughter were grabbing the items and putting them into the cart. It was on a Friday evening, about 1 hour prior to the store closing for the evening. As our client was leaving one aisle and entering an adjacent aisle, her foot slipped out from under her. Her knee came down, crashing down onto the hard floor. Her legs then did the splits, and she sat on the ground, writhing in pain. Our client screamed in pain, and her family quickly retrieved the store employees to give assistance. As she lay on the floor, she noticed a trail of what appeared to be water curving around the ground from one aisle to the other. Her pant legs began to soak up some of the water that was on the floor. Store employees arrived and noticed the water and grabbed some paper towels to clean up the water. Sadly, our client needed surgery on her knee and was out of work for over 1 year as a result of her continued medical treatment. Let's look at what was needed to be proved to have a successful case. First, we had to prove that the defect was a foreign substance on the floor. A grocery store should not have water on the floor, as that is a foreign substance. Check, got that one. Next, we must prove that the grocery store was aware of the water on the floor. Uh-oh. The store insisted that the water was not placed there by an employee and that they were unaware of the water on the floor. Because obviously if they were, they said they would have cleaned it up. The water on the floor was not observable by our client, so therefore it was not open and obvious, so she wasn't aware of the defect. Lastly, there's no question that the injuries that she sustained was caused by the fall, as she did not have any problems before the fall. We were in trouble. How are we going to be able to prove that the store was aware or should have been aware of the water that was on the floor? Fortunately, through litigation, we requested copies of all the videography of the incident before and after the fall. The grocery store objected. However, the judge forced them to give us the video files. We actually had to hire a specialist to view the videos as the file format was in some proprietary format. There is where we learned that there was an employee cleaning the floors with one of those machines that sweeps, mops, and dries the floors as he drives up and down the aisles. He made the exact turn the client was making when she fell just 30 seconds before the fall. We examined the machine and found out that these machines leave a thin line of water when they make turns, something the store was fully aware of. Now that we found this smoking gun showing that the store was aware that the water was being deposited on the floor, the store had to settle or be subject to the possibility of a very large verdict. If you are a victim of a slip and fall accident or think about handling a personal injury case on your own, call me, Paul Hernandez, at 888-487-8546. The call costs you nothing, the consultation is private, and I can answer all of your questions. And by the way, if you enjoyed this video, click the subscribe button below. That way you'll be notified every time we post a new informative video. I'm Paul Hernandez, attorney at Kalfus Nachman. Thanks for watching.